morning, everyone. Welcome to our August 1st Friday webinar. We'll give everyone a couple seconds here to log in, and then we will begin. All right, good morning, everyone. We will go ahead and get started. The topic of our first Friday webinar this month is Wage and Hour Bootcamp, Essential Rules, Risks, and Staying Compliant. My name is Julie Schumacher, and I am joined today by my colleagues, Tara Paulson and Mark Folsom. Like we do all of our other webinars, we will start off before we get into the main topic today by going over some updates from the last month.
Let's start off with the first update. On July 21st, just a few weeks ago, the federal EEOC, Equal Employment Opportunity Commission, voted to approve a proposed rule which rescinds a number of longstanding agency requirements, most notably the Form EEO-1, which private employers of 100 or more employees have been required to file for decades. The proposed rule, and keep in mind it's still a proposal, will be published very soon in what's called the Federal Register, and folks will have an opportunity to comment on that. And then after that public comment period, the EEOC will likely take formal action to approve it as a final rule. For those of you who don't know, the EEO-1 report requires employers to submit aggregated demographic information regarding the workforce broken down by establishment in one of 10 EEO-1 job categories. This is the data which is submitted that allows the EEOC to monitor and enforce its civil rights laws. And arguably, it gives employers sort of a self-assessment of where they are in those, as far as race, sex, et cetera. One of the reasons why the Trump administration, and in particular EEOC Chair Andrea Lucas, want to get rid of the EEO-1 is, you may recall that the Trump administration has been targeting DEI programs. Their arguments generally fall into a couple buckets. One, they think that by categorizing or tracking this information, it may have the unintended consequence of leading employers to actually engage in unlawful discrimination, because they may see an imbalance and then say, we need to right the ship, if you will, and go hire more members of a certain protected class. Also, the Trump administration has said this is really just a substantial burden on employers to have to complete these documents and submit them. So stay tuned. We expect more developments on that, but right now it's a proposed rule. Open issue is, what do you do about 2025? They didn't open the portal for employers to submit those. There's a chance that employers would still be required to submit those for 2025, but it's highly unlikely. What is likely, however, is, depending upon who the next president is they may reinstate it. Also, understand that a number of states are now requiring similar data to be submitted on the state level. This is following a pattern when the federal government is either rescinding prior requirements or not taking action. A number of states, and I think you can traditionally lump those into what I'll call blue states. Here, there's going to be California, Massachusetts, Illinois, and now Colorado's looking at something as well. So the blue states are now requiring this, or may require this on the state level. Red states generally are not. And it looks like very soon the federal government will not require EEO-1 reports or require that data to be submitted. So we can go to the next highlight.
Right, next highlight, and is actually pertinent to our discussion today on wage and hour laws, is at the end of last month, so it was July 22nd, the Department of Labor issued 2 companion opinion letters that address the questions of when an employee's commute and pre-shift activities count as compensable hours worked under the Fair Labor Standards Act. And what's maybe more interesting about these two opinion letters is the U.S. Department of Labor offered some unusual detail on how the Wage and Hour Division is analyzing compensability. So again, these letters are addressing whether commute and pre-commute time is compensable under the Fair Labor Standards Act. They are particularly timely for employers who are managing hybrid and remote work arrangements, as well as employers who have field-based or dispatch workers who may start their day at home. The kind of primary framework that these letters rely upon are three different doctrines. One of those doctrines is called the primary beneficiary test. What that particular test asks is the time spent predominantly for the employer's benefit or the employee's? Another doctrine that these opinion letters address is what's called the continuous workday doctrine. What this doctrine says is once a first principle activity begins, time is generally compensable until the last principle activity ends. And then that third doctrine that is discussed in these opinion letters is what's called the Portal to Portal Act. And this is a statute that excludes ordinary commuting and preliminary and post-preliminary activities from compensable time, but only for those things that happen before or after the workday. Activities that are, quote, integral and indispensable to an employee's principal work are compensable. So again, those are three doctrines that are often discussed by the Wage and Hour Division in determining whether hours worked, or whether the time spent is hours worked and thus compensable. And we're going to go over both of these opinion letters in the next couple of slides, but that's the framework to be kind of approaching these. So Julie, why don't you take the first one on midday commuting?
Yeah, so as Tara mentioned, the first of the two opinion letters addressed midday commuting when you have employees who work partially in an office, partially at home. What this letter addressed, the DOL, the Department of Labor, reviewed whether travel between an employee's home and office during the middle of the workday must be treated as compensable time under the FLSA when the employee performs work at both locations and the travel is a voluntary alternative to commuting before or after the workday. So this letter looked at three specific scenarios that we'll go over quickly here. So the first scenario was a situation where a non-exempt worker is scheduled to work between 9 a.m. and 5 p.m. and typically commutes to the office from 8 a.m. to 9 a.m. and home from 5 p.m. to 6 p.m. So driving 2 hours daily is not ideal for this employee. So this employee who wants to avoid the rush hour traffic has asked to commute between 10 a.m. and 10:30 a.m. and 3 p.m. and 3:30 p.m., reducing the total drive time by 1 hour. The employee requests to work at home from that 8 a.m. to 10 a.m. before they commute in, and then from 3:30 p.m. when they arrive home to 5 p.m. after returning home from the office. So the employee takes a 30-minute lunch break at noon, regardless of the location. So either arrangement results in the employee working a normal schedule of 7.5 hours. The second scenario that the Department of Labor addressed is one where a non-exempt employee volunteers to work additional hours for a special project that is short-staffed. However, the employee is only interested in the work if the employee can perform the additional work during the early hours of the morning before leaving for her regular shift at the office, instead of arriving at the office early or staying late. The last scenario that this letter addressed was one where a non-exempt employee uses the city bus to commute to and from the office and is unable to complete his day's work before the last bus leaves for the day. The employee asks the employer for permission to bring his work home to complete the work after arriving home. So what the DOL confirmed in addressing these scenarios is that the home to work travel time in each of these would not be compensable ordinary commute time. The Department of Labor specifically rejected the idea that once an employee performs work at home, any subsequent travel between home and office automatically becomes compensable under the continuous workday doctrine that Tara just talked about. Instead, the DOL identified 3 categories of time that commonly occur within the workday but are not compensable hours worked, regardless of where they occur in a workday. And those are 1, bona fide meal periods, 2, off-duty periods, and 3, ordinary home-to-work commuting. The opinion emphasized the longstanding principle that time is work if it is spent predominantly for the employer's benefit rather than the employee's. If home to work travel is undertaken principally to accommodate an employee's preferences or needs, it remains ordinary commuting. It is not compensable regardless of when it occurs during the workday. So Mark will talk about the next opinion letter.
Next opinion letter is number 10 from 2026. And in this one, a little background is appropriate. We had a field service engineer who installed and serviced MRI machines. He didn't have a fixed office, and he drove a company-provided vehicle from his home to client sites to go work on these machines. Between 7 a.m. and 8 a.m., he would receive several pages with service requests, and then he would call clients to schedule appointments and sometimes call other engineers to cover or assist before driving to his first job. His paid shift ran from 8 a.m. to 5 p.m., and he inquired in this opinion letter request whether the FLSA requires him to get paid for receiving the pages, for making those calls on the service calls or to other engineers, and for driving to that first appointment in 2 separate scenarios. One, where he completes the calls at home and then leaves at 8 a.m. in the company provided vehicle, and one where he must leave earlier and then makes the calls while he's driving to that first appointment. So here, the Department of Labor Wage and Hour Division drew a careful line between receiving assignments and acting upon them. Under federal law, the amendments to the FLSA that occurred, I think, in the late 90s, use of an employer-provided vehicle and activities incidental to that use are not principal activities. So merely receiving those pages was not compensable time. Calling clients to schedule appointments and coordinating with other engineers, however, is required to be paid. So that's paid time. So it's that receiving a page is not compensable, but actually calling to schedule service appointments, calling other engineers to try and line them up to cover appointments, that is compensable. Because the client calls were what the DOL called a principal activity, they start the continuous workday. But is the ensuing drive to the first site still part of the ordinary commute, which is not compensable, or is it part of the principal activity and part of the continuous workday? And here, Department of Labor said that once the workday begins, really the statute offers no guidance on what counts as compensable work. But drawing on the letter that Tara just discussed, the drive is where it's not ordinary. It's not just going to the office, but it's actually going here where they are doing actual other work that's principal, that's part of the continuous workday, and where it requires the engineer to spend most of the pre-drive hour on calls. That says that in that incident, it is in fact compensable time. Bottom line, receiving pages is not compensable, but calling clients and scheduling appointments is. So that's the biggest takeaway. Obviously, there's a lot of different factual scenarios you could throw into this. And so DOL recommended that reaching an understanding with the employee as far as what is compensable and what is not, and reducing that to a written agreement. And as long as that reasonably attempts to adhere to and comply with the FLSA, Department of Labor is going to give that a lot of weight. So again, try to avoid the uncertainty by reaching agreement with the employee as far as what is compensable and what is not.
All right, so if that sounded incredibly hyper technical to you, we're going to go ahead and offer a couple of key takeaways we want you to know as this particular development came into play at the end of last month. One key takeaway: there is now a named exception to the continuous workday doctrine, which is an ordinary commute. So now if someone is doing an ordinary commute and it is during the workday, that is non-compensable time. Another takeaway: vehicle ownership and timing are not decisive. So an employer vehicle neither makes an ordinary commute compensable time, nor does it shield otherwise compensable travel. Commute analyzed in the middle of the day is analyzed no differently than if it was at one starting end of the day or the end of the day. And then, as Mark just mentioned, the inquiry is certainly fact intensive, and it is fact intensive by design. Some action items for you to consider: if you have any hybrid or split day work arrangements, confirm that that midday commute is genuinely voluntary primarily for the employee's benefit and free of actual work during that travel. You could consider auditing pre-shift practices for your field and dispatch employees to distinguish non-compensable receipt of routes, pages, or assignments from compensable scheduling, calling, and coordination of work. And then finally, confirm that your organization has a timekeeping system that allows employees to capture all-time work, both at home and in the field, regardless of their location. If at work time is variable and hard to measure, as Mark just mentioned, consider using a reasonable agreement that you can rely upon moving forward. So hopefully that sheds a little bit of light on those new opinion letters.
Yeah, so our topic today is wage and hour training. And the reason we thought this was a timely topic is, in addition to what's happening now at the Department of Labor, there's also a lot of legislation out there and some recent litigation related to wage and hour matters. So just to give you kind of a preview of why this topic is important, just recently in the past couple months, there has been class actions in California and Washington related to meal and rest breaks. Beyond Washington, there have been about 20 states that have adopted meal or rest break requirements. And there's a patchwork of inconsistent state laws that are getting more and more complex. The state of Minnesota just created new requirements and penalties regarding meal and rest breaks this year. Many state courts have also rejected the Portal to Portal Act under state law, which opens the door for claims related to pre-shift activities when those are compensable, even time that employees take walking to clock in. Even under the FLSA, plaintiffs are bringing suits related to computer boot up time, whether that should be paid, and challenging employers' rounding practices that have been used for decades. Additionally, there are pay transparency laws that are rapidly expanding. About 20 jurisdictions now require some form of pay range disclosure. So there's a lot going on in the wage and hour space. So we'll go over some of the main principles over the rest of the slides, and then we will do a little quiz at the end. So here's our roadmap for training today. We'll start with the federal law. We'll then discuss state law requirements, and then we'll do the test your knowledge at the end.
All right, our primary law we're going to deal with is obviously the Fair Labor Standards Act, but there's some other laws that and executive orders that come into play. We have the Family Medical Leave Act, which really was patterned somewhat off the Fair Labor Standards Act. We have the Davis-Bacon Act, which deals with government works or public works contracts, and executive orders issued by the various presidential administrations that apply to federal contractors. First one is we'll talk about, and Tara's going to give you the detail on it, is you got to ask yourself, is our organization, are we a covered employer under the FLSA? And this law differs from other federal employment laws, which Tara is going to highlight here in a second.
All right, so one of the first questions we ask ourselves is the worker an employee? Because the Fair Labor Standards Act only applies to employees. Under the FLSA, the term employee is defined really, really broadly. The statute defines an employee as any individual employed by an employer. It then goes on to define employ to mean to suffer or permit to work. So again, we've got a very broad definition of who is covered under the Fair Labor Standards Act. It's any individual who is has to suffer or be permitted to work.
We suffer every day, don't we? Anyone who works.
Exactly.
It's all about suffering.
If you are someone who is just kind of wondering what that all means, here is what we take a look at. Courts have applied what's called the economic realities test, and that's primarily because this federal statute, its definition is fairly circular. So courts have applied what's called the economic realities test. And what that means is the court's considering a number of different non-exclusive factors. Courts are going to look at the degree of control exercised by the employer over the worker. More control, more likely that the worker is going to be deemed to be an employee. They're going to look at the worker's opportunity for profit or loss. If they have that opportunity for profit or loss, then it's more likely that they're going to be an independent contractor, not an employee. They're going to look at things like the worker's investment in the equipment or materials required for the work. They're going to look at whether the work requires specialized skill, initiative. They're going to look at the performance or duration of the relationship. If that relationship is essentially indefinite, more likely that the worker is going to be deemed to be an employee. They're also going to look at whether the work is an integral part of the employer's business. So again, a number of factors that courts are going to look at. The definition is going to include, most often, all full-time employees, part-time employees, temporary employees, seasonal employees, and even day laborers as well. Sometimes easiest way to think about who is covered is to also look at who's not covered. So Julie, why don't you take us through that? That might help provide some guidance to our listeners here today.
Yeah, sure. So depending on the facts, the following kind of buckets of workers may not be employees under the FLSA. So the first is, like Tara mentioned, properly classified independent contractors. The FLSA also would not cover bona fide volunteers for public agencies and certain nonprofits, subject to specific rules. It also would not cover business owners who are genuinely operating their own independent businesses. And it also wouldn't cover certain interns or trainees whose relationship primarily benefits the intern under the primary beneficiary test. So these buckets have different tests and factors for determining who's what. Like Tara said, with the independent contractors, we use what's called the economic realities test. With interns, there's a slightly different test. It's called the primary beneficiary test. So when a court would determine is someone an intern or are they an employee, they'd look at certain things such as the fact that perhaps the intern is part of a formal education program. They'd look at whether the intern expects compensation, if there's a clear understanding. They'd look at things like, is the employer providing training to this intern? Perhaps the period of time that they're working is tied to an academic calendar. That might lend itself towards an analysis that this worker is actually a trainee or an intern. A court would also look at whether or not this intern's work displaces the work of paid employees. So those are just some of the factors. But again, yeah, different tests for determining what types of workers are employees under the FLSA.
So the FLSA generally has 4 buckets of things that it regulates: minimum wage, overtime, child labor, and record keeping. Our focus today is largely on overtime, to a slightly lesser extent minimum wage. We don't have enough time to address child labor and record keeping today, but let's jump right in. So when you have someone who is non-exempt, meaning overtime eligible, meaning they're eligible to receive overtime, and you can't just, it's not just because they are paid a salary, and we'll get to that in a second, but essentially for non-exempt overtime eligible employees, they must receive 1 and 1.5 times their regular rate of pay for all hours worked over 40 in a work week. And so regular rate of pay has meaning, hours worked has meaning, and work week has meaning. Well, how does someone become exempt? One, they can qualify for one of the statutory exemptions that apply. The biggest of those is the white collar exemptions, which we'll get to in greater detail here in a second. But there's also industry specific exemptions. There's an ag exemption, and ag has kind of a wonky definition, 2-part definition, how you may qualify. There's an exemption for those who are engaged, who fall under and are regulated by the Motor Carrier Act. There's industry specific regulations for cheesemakers, as well as those who are involved in fishing, and they process the fish while still at sea. So again, you'll need to determine whether your industry qualifies for an industry exemption, and then you'll probably then have to go look at the white collar exemptions to determine whether any of those apply as well.
All right, so as Mark mentioned, under the Fair Labor Standards Act, employees are entitled to overtime for all hours worked over 40 in a work week unless the employee qualifies for an exemption. The most commonly used exemptions are what are called the white collar exemptions. Sometimes they're referred to as EAP exemptions, standing for executive, administrative, or professional employees. These terms are not defined in the Fair Labor Standards Act. Congress delegated responsibility to the U.S. Department of Labor to come up with the appropriate definition of these exemptions. And for employees to qualify for the EAP or white collar exemption from overtime requirements, employees have to meet all three of the following requirements. First, is called the salary basis test, or they have to receive a fixed salary. The employee has to receive a predetermined salary that's not subject to reduction based on the quantity or the quality of the work that's performed. If the employee works 30 hours that week, the employee receives the same fixed salary as if they worked 50 hours a week. If they produce 2 widgets, they receive the same salary as if they produced 15 widgets that week. That's called the salary basis test. In addition, that individual has to receive a specified minimum salary per week in order for this exemption to apply. The current amount that an employee has to receive for this exemption to apply is at least $684 a week, which is the equivalent of $35,568 a year. And then finally, a third test must be met in order to have one of these EAP exemptions apply, and that is called the duties test. The employee's primary duty must meet the requirements for each of the applicable exemptions. So there is a different duties test for the executive exemption compared to the administrative, professional, computer, employer, outside sales. So we're going to go through each of these EAP exemptions so it is clear to you how someone can meet one of these exemptions and then not be entitled to overtime for hours worked over 40 in a work week.
Yeah, so the first of the EAP exemptions is the E exemption, which is the executive exemption. So in order to qualify for this exemption, one, like all of them, you have to be paid on a salary basis. Minimum salary of $684 per week. The primary duties for this exemption have to include: 1, management of the enterprise or a customarily recognized department or subdivision of the enterprise. The employee must customarily and regularly direct 2 or more full-time employees or full-time equivalents, and has to have the authority to hire and fire, or whose suggestions for personnel decisions are given particular weight.
So the next, if we're following the alphabet, we got E, we now have A, which is the administrative exemption. This is by far the most gray and vague of all the EAP exemptions. I think most employers, far too many, think that anyone who works in an office is administrative and therefore exempt. That is not correct. First, as Tara and Julie both mentioned, you must be paid on a salaried basis. So it's receiving the same amount of pay each work week, regardless the quality or quantity of work performed. 2, that minimum salary must be at least $684 a week, and they must have a primary duty of office or non-manual work. So that's easy if you're working in an office, but that work must be directly related to the management or general business operations of the employer. And it's key word there. And that employee must exercise discretion and independent judgment with respect to matters of significance. I, to this day, have no idea what that means. I know what it doesn't mean. If the decision is, I am the receptionist, I'm deciding what calls to put through to the company president, not going to meet it. It's got to be something of significance that actually can affect the organization or business. And so this is often an audit risk for most employers because they have too many folks who are misclassified as qualifying for the administrative exemption and therefore not receiving overtime when in fact they probably don't qualify.
All right, the P exemption, the professional exemption, again, individual has to be paid on a salary basis. It has to meet that minimum of $684 a week. And then their primary duty can fit one of these particular categories. So first, learned professional. If the employee's primary duty requires advanced knowledge, that person can fit under this professional exemption. The regulations identify several recognized fields of science or learning that can qualify for this learned professional exemption. Those fields are in things like law, medicine, theology, accounting, engineering, architecture. Employees who will generally satisfy this particular exemption are attorneys, certified public accountants, physicians, pharmacists, engineers, architects, teachers. There is another category of professionals who can fit this exemption, and those are creative professionals. These are individuals whose primary duty requires work involving invention, imagination, originality. Really, the regulations identify these types of fields, those that are in music or writing, acting, graphic arts. Employees who are generally going to fit this type of exemption are actors or musicians, composers, conductors, those types of individuals. Another subcategory of individuals who can fit this professional exemption is if you are someone who is a computer professional. This is where this particular exemption has a little bit of a nuance. Here, the computer professional can either be paid on a salaried basis of a minimum of $684 per week, or they can be paid on an hourly basis as long as they are making at least $27.63 per hour. For an individual to qualify under the professional exemption as a computer professional, they have to be in charge of things like designing, developing, documenting, analyzing, or creating computer systems or programs. Sometimes there's a misconception that if you've got an employee who is in IT or a help desk type personnel, those individuals do not qualify as a computer professional under this professional exemption. We are really looking at those that are involved in the manufacturing or development of computer hardware and software. So that covers our professional exemption.
Yeah, so in addition to the EAP exemptions, there is also an exemption for employees engaged in outside sales. So to qualify for this exemption, there is no salary requirement. There's only a duties test here. And the duties here are that the employee is one, making sales or obtaining orders or contracts for services or use of facilities. And lastly, has to be customarily and regularly engaged away from the employer's place of business. So employees who do inside sales do not qualify for this exemption.
Last but not least is the highly compensated employee exemption, which came to be in 2004, sort of a compromise. The Bush administration at that time was trying to find a bright line test saying if you made over at least X of salary, you were automatically exempt. So you didn't have to go through the duties analysis. That's not where they landed. Compromise says you got to make at least 107,432 in total comp. So it's salary, maybe bonuses and maybe commissions. Also, their duties must be one or more of the duties for the executive, the administrative, or professional. And so it's not as complicated as the other tests, as long as they're making at least 107,452 a year. If you get to the end of the year and you aren't quite at 107,000, you could do a one-time catch-up payment at the end of the year, within 1 month after the end of the year, to preserve that exemption. So you can maybe pay them a flat 100,000 and then make up the rest, see where they're at on bonuses and commissions at the end of the year, and still maintain that exemption. We don't see this very often, but you should know that does exist.
Another issue to flag for all our participants today, or not participants, I saw the word prizes and I thought participants. So another issue for all of our attendees to be mindful of today is the issue of gifts, prizes, or bonuses under the FLSA. You might be asking yourself, why does this matter? Well, as Mark mentioned, when we first started delving into this topic, employees are entitled to 1.5 times their, quote, regular rate of pay for all hours worked over 40 in a work week. What happens if an employee receives a gift or a prize or a bonus? How is that to be calculated, if at all, in determining their regular rate of pay? We'll go over a couple of the basics. As it relates to gifts, gifts that are paid as a reward for service are generally excluded from the regular rate so long as the amounts given as a gift are not measured by or dependent on hours worked, production, or efficiency. Similar for prizes. If someone gets a prize through maybe a company raffle, that is not something that needs to be included in the regular rate of pay. However, if a, quote, prize given to an employee is a part of their job, for example, maybe they get a prize for attendance, or maybe they get a prize for not getting caught by some sort of IT test phishing message, then that would be something that has to be worked back in to their regular rate of pay if the employee has overtime hours in that particular week. Bonuses, deal with bonuses is a question as to whether or not that bonus is discretionary or non-discretionary. If the bonus you pay to an employee is discretionary, then it does not need to be included in the employee's regular rate for purposes of calculating how much to pay for overtime. To be discretionary, the employer, so you all, have to retain discretion as to whether to give the bonus and what the amount of the bonus is. Think of end of year, maybe holiday bonus or Christmas bonuses. So long as the employer is retaining the discretion whether to give it and what the amount is, then it does not have to be included. However, if the bonus is a non-discretionary bonus, perhaps you have a system in place that says, we are going to give you $10 for every 2,000 widgets that you produce. That is a non-discretionary bonus. You have already told your employees, if you do X, then you get Y. You have not retained any discretion. And so that amount of that bonus has to be worked back into the regular rate of pay. One final nuance that can come into play is if a bonus can be linked to a particular work week, then that bonus has to be worked into the regular rate of pay for that work week. However, sometimes a bonus cannot be linked to a particular work week. And if that's the case, then you as the employer have to adopt some other reasonable and equitable method for determining how that bonus is going to get worked back into regular rate of pay.
Another issue under the FLSA we want to flag for you is the issue of wage deductions from exempt employee salaries. So as we mentioned earlier, many of the exemptions require that the employee is paid on a salary basis. There are scenarios where if an employer makes a deduction from the employee's salary, the employer could risk losing the exemption for that employee. There's even a penalty under the FLSA that you can risk losing the exemption for everyone in that employee's job category. So deductions can be a big deal. So we wanted to go over what some of the permissible deductions are from an exempt employee salary and what deductions are not permissible. So there are 7 scenarios that we know are permissible to deduct from an exempt employee salary. The first one is for a full day personal absence. So when the employee misses 1 or more full days for personal reasons other than sickness or disability. The second one is full day sickness or disability only if the deduction matches a bona fide plan, policy, or practice of providing compensation for loss of salary caused by sickness. The third scenario where a deduction is permissible is an initial or final week of employment. So employers can prorate the salary for the exact number of days worked during an employee's first or last week of employment. The fourth scenario that's permissible is for FMLA leave. Any hours taken as unpaid leave under the FMLA can be deducted. The fifth permissible scenario is for safety violations, so penalties imposed in good faith for infractions of safety rules of major significance. The sixth scenario is where there is a disciplinary suspension, so an unpaid suspension of one or more full days imposed in good faith for infractions of written workplace conduct rules. The last scenario that it is permissible is to offset amounts received by an employee for jury fees, witness fees, or military pay. So you cannot deduct, those are the situations where you cannot deduct from an exempt employee's salary for the following reasons, which we commonly see. So one, for a partial day absence, so deducting pay for missing a few hours of work is strictly prohibited. Two, you cannot deduct for business closures, so you can't deduct pay because the business closed for a holiday or due to inclement weather when the employee was ready and able to work. And three, lastly, you can't deduct for performance quality, so you can't reduce pay based on quality or quantity of the employee's work.
Next topic that comes under wage and hour law is break time from others. A lot of folks don't realize that when the Affordable Care Act was adopted in 2010, they actually amended the Fair Labor Standards Act. They didn't create a new law. They didn't amend Title VII. They didn't amend the Pregnancy Discrimination Act, but they actually amended the FLSA to require employers to provide reasonable break time for nursing mothers, sometimes referred to as lactation breaks. Then in December of 2022, the PUMP Act was adopted, which expanded the coverage and protections to include exempt employees as well. Generally, covered employers must provide employees with both a reasonable break time to express breast milk for the nursing child each time the employee has a need to do so, as well as a place for the employee to express breast milk that is, it can't be a bathroom, must be shielded from public view and free from intrusion from coworkers in the public. The law has a whole host of other requirements, including employees are eligible to receive that break time for at least 1 year after the child's birth. Employers are not required to pay employees for the break time unless the employee is not completely relieved from duty during the entire break. It doesn't preempt state or local laws, which may provide employees with greater protections. And for those employers that have 50 employees or less, if in fact doing so would create an undue hardship for the employer, they don't have to actually implement these requirements. That being said, we generally recommend that undue hardship test is pretty hard to satisfy, and so you should make a reasonable, good faith effort to try and comply with the act, even if you employ fewer than 50 employees.
All right, so now that we have covered some of the things that arise under federal law, we're going to give you a little bit of tutorial about state law wage and hour issues, and those are going to stem from 3 different statutes. 1, the Nebraska Wage Payment and Collection Act. 2, what's called the Nebraska Lunch Hour Law. And then 3, Nebraska Paid Sick Leave. So first, turning to the Nebraska Wage Payment and Collection Act, it generally is going to regulate things like deductions from pay and what can be deducted from an employee's pay. It's also going to cover what wages are due upon separation, and it regulates things such as accrued vacation and accrued PTO and how that needs to be handled at time of termination. And it's also going to address commissions. This is an area where we often, at least maybe once a month, we have a client who calls in with a question on what commissions are owed to an employee at time of termination. And so we included this language on this slide for you. What the statute tells us is unless there is a contract effective at the time or commencement of employment, or at least entered into 90 days prior to separation, whichever is later, wages includes all commissions on all orders delivered and on file with the employer at time of separation of employment, less any orders returned or canceled at the time suit is filed. So if you have an employee who receives commissions, unless you have put together an agreement that says differently, you are going to continue to owe that employee commissions even after they have ended their employment with you. So that leaves the question, what do you do if you want to try to prevent that from happening? our answer, contact your employment and labor council so that they can properly draft an agreement that works around this definition of commissions found in the Nebraska Wage Payment and Collection Act. Other kind of issues maybe that come up under Nebraska Wage Payment Collection Act, or when can you deduct for uniforms, shortages, theft. Oftentimes you're not going to be able to deduct from somebody's pay unless if it's going to drop that individual below minimum wage. An exception to that is if someone has unearned vacation or maybe was overpaid, you can deduct from someone below minimum wage in those types of scenarios. This law tells us that that's more like a bona fide loan.
Another state law specific thing we have here in Nebraska is a somewhat archaic lunch hour law. This was a law that was adopted in 1931 and applies only to assembly plants, workshops, and mechanical establishments. There's no definition for these terms. What the law says is that employees who work for these employers have to get a 30-minute lunch for every 8 hours worked. So we're not aware of this law ever being enforced or litigated. However, as we mentioned earlier in this presentation, meal and rest breaks are becoming a hot button topic for plaintiffs' lawyers. And there are a bunch of new state laws related to meal breaks and rest breaks that employers need to be aware of. We know we have a lot of clients who have employees in Minnesota, and they just passed a new law this year. So to the extent that you do have employees in other states, you'll want to consult with counsel and make sure that you're abiding by these nuanced lunch hour and meal break laws.
Next one, unless you have been living under a rock, you know that as of October 1st of last year, the Nebraska Healthy Families and Workplaces Act, or the Paid Sick Leave Act, went into effect. And obviously, if you didn't know that, you haven't attended the umpteen number of webinars that we've done on that very topic. We do have an update on this. Checking the Nebraska Department of Labor website, they have now actually published on their website one employer who apparently was cited and has not paid the fine, and that's Noli's Pizzeria in Omaha. So if Noli's is on, feel free to call us because you need some help. The fine is generally $500 for the first violation and up to $5,000 for subsequent violations. So this law is very detailed. Feel free to watch our past webinars on the details of it, but it does in fact apply to all private sector employers of at least 11 employees and does not apply to government employers in the state of Nebraska.
All right, this brings us to our quiz time. So now we are going to test your knowledge and I suppose also test Mark, Julie, and I's training on wage and hour issues. So let's go ahead and bring up question number 1. You are asked here, which of the statements is most correct? A, the FLSA requires employers to provide meal periods. B, the FLSA does not require employers to provide meal periods, but does require rest breaks. C, if an employer provides short rest breaks, the time must be counted as hours worked. Or D, if an employer provides meal breaks, the time does not need to be counted as hours worked. Give you about 3 seconds to think about what your answer there is.
3, 2, 1.
All right, most correct answer here is C. FLSA does not tell us that we have to provide rest breaks or that we provide meal periods. It does give us guidance, however, that if we do allow short rest breaks, 15 or so or 20 minutes, those do count as hours worked. For meal break periods that exceed 30 minutes or more, assuming that the employee is relieved of all duties during that meal break of 30 minutes or more, that does not have to be counted as hours worked. So your most correct answer here is C. If an employer provides short rest breaks, the time must be counted as hours worked.
All right, our next question. When calculating the regular rate of pay, which statement is the most correct? Your options are A, discretionary bonuses like a Christmas bonus do not need to be included. B, extra pay for working weekends and holidays does not need to be included. C, A and B are both correct, or D, A and B are both incorrect.
3, 2, 1. Did you get it right?
Correct answer is C. A and B are both correct. So if you'll remember when Tara was talking about gifts, prizes, and bonuses, we know that discretionary bonuses like a Christmas bonus do not need to be included. Also, extra pay for working weekends and holidays does not need to be included. This would not fall under the category of a non-discretionary payment, such as one where the employee was promised extra pay if they achieved some kind of productivity marker or they achieved some predetermined level. Both A and B would not need to be included in the regular rate.
Next question. Employers can establish comp time policies under which non-exempt employees, instead of receiving overtime pay for hours worked over 40, can bank that time and take it off as paid time off at a later date. Which is the most correct answer? A, true. B, false. C, partly true and partly false. Give you 3 seconds. 3, 2, 1. We're a good lawyerly answer, right? So, little history on comp time. So, in 1985, the U.S. Supreme Court decided the case Garcia versus San Antonio Metropolitan Transit Authority. And that case overruled a long time precedent that said the FLSA does not apply to state and local governments. So, suddenly, as of that date in February of 1985, state and local governments discovered, by virtue of this court case, wait a sec, we have to pay overtime? And so, what do you do when you're in the middle of a budget crisis, budget cycle, and you haven't budgeted for overtime? In this particular instance, Congress actually took action and in November of that year adopted a law to address this very issue. And one of the changes it made to the Fair Labor Standards Act is found in Section 7.0 of the FLSA. And that says that essentially public employers, state and local governments, so this does not apply to private sector organizations, does not apply to nonprofit organizations. It's only government. Government employers can allow an employee under some restrictions, instead of paying them overtime, to allow them to bank comp time to be used at a later date as paid time off. Generally, this requires an agreement or understanding between the employer and the employee. Often this is found in a collective bargaining or a union agreement. But if you don't have a union, you'll want to have something in your employee handbook, which is then signed and acknowledged by the employee, understanding that this policy applies to them. There are caps on how much they can bank. Generally, for most employees, it's 240 hours, which is actually, that's 160 hours plus the overtime. You get the halftime premium, so it's 240 hours. For employees who are involved in emergency response or seasonal work, you can go up to 480 hours. Employees must be able to use that comp time generally when they want, unless it would create an unless it would unduly disrupt the employer's business or organization. So there are some restrictions on that. You want to make sure your policy complies with that. But if you're a private sector organization, if you're a nonprofit, if you're a business and you're not a state or local government, you cannot have or establish a comp time plan, as it will violate the FLSA.
All right, question number 4. So long as the employer doesn't use the tip credit, salaried managers and supervisors can participate in a tip pool and receive their fair share of customer tips. We didn't necessarily cover this in the previous slide, so I'm going to give you a leeway if you don't get this one correct. But your answer choices are A, true, B, false, or C, partially true and partially false.
We'll give them 4 seconds this time.
4, 3,
2,
2, 1. All right. Correct answer here is false. Couple of things to note. If you have a workforce that receives tips, you probably know this already, but you can pay a tipped worker $2.13 per hour under both the FLSA and under Nebraska law, and then take a tip credit equal to the difference between that wage and what is paid to that employee in tips. But no matter what, you do have to make sure that they at least make minimum wage. So if that if they don't get there by way of tips, then you do have to make up the difference. So here in Nebraska, a tipped employee can be paid $2.13 per hour in wages if tips bring their earnings to at least $15 an hour, since that's what our state minimum wage is. But you as the employer do need to ensure that that is met for every shift, and follow both federal and state tip credit rules. And there's some nuances as it relates to tip credits, and how that works. If you have questions, reach out to your labor and employment counsel.
All right, our next question. An employer can suspend an exempt employee for 3 days without pay for violating a company policy without losing the overtime exemption. Is this statement true, false, or partly true and false? Give you a couple seconds. So the correct answer here is partly true and false. So it depends on what the violation was. So what we know from the FLSA is that certain violations of company policy, if the employee violates it, they can be suspended for a whole day. You can deduct from their salary for things such as safety violations or sexual harassment. However, if you're going to deduct from an exempt employee's salary for other violations, such as perhaps they violated your vaping policy or they violated your dress code policy, those types of violations, if you're going to suspend them and deduct from their pay, it has to be pursuant to a written policy. So you want to make sure that's something that you've got in your employee handbooks.
Next to last question. Adley was a maintenance worker for Acme, which is a Nebraska company. Adley quit last Friday and didn't return the keys issued to him for the company's 7 buildings. Can Acme withhold the cost of rekeying its locks from Adley's final paycheck? And actually, this is a fairly common question we get. Correct answer, yes, no, or C, it depends. Give you 2 seconds to answer this. 1, 2. It depends. Of course, we're going to give you a lawyerly answer. So, Nebraska Wage Payment and Collection Act says that in order to make any deduction from an employee's pay, it must fall into one of 3 buckets. 1, it was required by law, such as taxes. 2, is required by court order, such as child support or garnishment. Or 3, the employee has authorized the deduction in writing in advance. So if you've had them sign an agreement that says when they leave, if they owe you anything or haven't returned the keys, you can make the deduction from your final paycheck, then you're great. You can do it. With one sort of nuance there, you can't drop them below the minimum wage. That kicks in the federal Fair Labor Standards Act. So you got to deal with the Fair Labor Standards Act as well as the Nebraska Wage Payment Collection Act. So you want to make sure that you have them acknowledge that. We often put that in the employee handbook and have them acknowledgement in the acknowledgement form, and then make sure you don't drop them below the applicable minimum wage, federal or state, when you make that deduction for those keys. Let's get to the last question.
All right, final question. Question number 7. Judy, a customer service representative at XYZ Corporation, prides herself on being a hard worker. After working a full day, Judy often spends her evenings responding to customer emails to make sure that she starts each workday with all customer issues resolved. XYZ Corporation has a policy requiring all employees to record and report all hours worked for XYZ. However, Judy feels she needs to catch up on work emails at night because she feels she was inefficient during the workday, and for that reason doesn't record and report the time spent at home at night responding to emails. Your answer choices are A, Judy has a claim under the Fair Labor Standards Act for that time that she's not otherwise receiving compensation for at night for responding to emails, or B, Judy does not have a claim under the Fair Labor Standards Act. 3 seconds. 3, 2, 1.
I would add a C. I would add a C, that Judy is one heck of an employee. Let's keep her on board. And Judy's so good, she would never think about suing the company. But that's not the right answer.
Thank you, Mark, for your wishful thinking there. Here, I suppose there really should have been an answer choice C, which is maybe A or maybe B. I think you would want a little bit more information before you can appropriately pick A or B. And here's why. if an employer has a reasonable process for an employee to report uncompensated work time, the employer is then not liable for non-payment if the employee fails to follow that established practice. And there's a number of cases that have cited that particular provision. However, you got to be a little bit careful. Courts have found that if an employer has a formal policy for reporting overtime, but the employer prevents or discourages accurate reporting of overtime in practice, that policy is not going to save the employer. So here we probably want to know a little bit more about XYZ's policy, and two, their culture about whether they discourage or try to prevent employees from recording that uncompensated work time.
Thank you for joining us today. Our next First Friday webinar will be September the 4th at 11 a.m. If there's any topics that you would like for us to present on, feel free to send them our way.
Thanks, everyone.